Welcome to today's program titled Using Artificial Intelligence to Support DEIB Efforts. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Rachel C. Rachel, please go ahead.
Hi, Donna. Thanks for joining us this morning, this afternoon, depending on where you are. I'm Rachel C. I'm a senior counsel at Seyfarth's Washington, D.C. office, and my practice focuses on AI risk management. Before joining Seyfarth last year, I was at the EEOC working on AI policy and other issues. And I was looking back at some older presentations. I think my first presentation on AI and employment issues was back in 2019. The world is very different today than it was when we were talking about AI than it was last year or the year before. This is a very rapidly changing area of the law in HR. And some of, the same old numbers, I want to focus on DEI today, but want to just do some level setting and say, well, hey, where does DEI and DEIB efforts fit into some of what you're hearing about AI? So the old news, or at least I hope it's old news to folks of you thinking about HR, is that there are a lot of AI applications out there. And the very often cited numbers from SHRM, the Society for Human Resources Management, talk about how many HR departments are already using or planning on using AI in some form. And so SHRM's bottom line assertion is by 2025, half of HR departments could be using AI. I think this number is low. With love and respect for my friends at SHRM, I think there's a bunch of ways that people responding to SHRM's research might not be including LinkedIn Recruiter and other sourcing products in their list of AI tools. So the other, digging into SHRM's research, there's a great push of adoption in the HR industry going on right now. And I think that's leading to a bunch of FOMO. For those of you who haven't heard that term or aren't familiar with that term, I think in the tech sector, folks use it a lot, FOMO, the fear of missing out. I think there's this fear that if our competitors are all using AI and our competitors are using AI to find and acquire talent, that if a business doesn't use AI or a business doesn't capture those efficiencies, there's that fear that your competitors are going to be doing something better, faster, eating your lunch in a way. And I think that fear can both drive technology adoption and also can get people to do things in a riskier way than they might want to. The other thing that I think is interesting is that as outside counsel, as a former regulator, I often hear the lawyers be the voice of no. And I think with all of the FOMO out there, with all of the fear out there about AI, it's easy for folks having this discussion or thinking about this kind of discussion about AI and how folks can use AI to lose sight of why we're doing this in the first place, of what are the problems that people are trying to solve with AI. And so our current state of affairs, the current state of affairs from SHRM's research is that when we're talking about HR use of AI, most of it, 64% of the people saying that they're using AI already are using it for recruiting, interviewing, and hiring. And there's a long tail of other applications that people are admitting to using. And I think, certainly that recruiting, interviewing, and hiring component is where a lot of folks are hoping to capture efficiencies, but it doesn't tell the whole story. It doesn't tell the whole story about what people are thinking the use of AI for DEIB efforts might be. Okay, so here's the part that I think is really valuable for DEI practitioners, for folks looking at what the promise of AI is for enhancing DEIB issues. So according to SHRM's research, their really comprehensive survey of HR professionals using AI, 1 in 3 who are using AI are saying that the diversity of their hires is either somewhat or much better because of their use of AI. So let me say it again. They feel that by using AI, they are getting to a more diverse pool of talent. So specifically, what SHRM's recent survey research is showing us is that for the people using AI already, and this is of course in recruiting and in sourcing, recruiting, hiring, it is that by using AI, they are improving their ability to identify diverse candidates or to access underrepresented pools of talent that they weren't previously reaching. And those are the numbers that SHRM's research is showing and that these products are trying to get to. Anecdotes are not data, of course, but thinking about all of the other ways that people are using AI, some of these very specific applications, these use scenarios that SHRM's research is showing us is that folks are looking at ways to deploy AI, to use AI, vendor products and otherwise, in ways that help them achieve these goals. There's one here in the middle that talks about reaching out to passive candidates and finding candidates with diverse background that, if not for AI, this employer feels they would have missed them. And also, other applications such as, this isn't on this slide, but there are AI applications that seek to mask protected characteristics from the review, from the human review. So the human reviewers are making decisions that are less prone to bias. There's other ways that, on my other AI presentations, I frequently urge people to think AI is more than ChatGPT. That there are a bunch of ways that we're familiar with ChatGPT and large language models, and the way that some of these AI tools are working are different than just ChatGPT. And if you're thinking that these AI applications that folks are using in AI in HR are simply asking ChatGPT to make decisions for you, I hope that's not what the product is doing or selling. And if you have people in your organization who are just simply asking ChatGPT or a large language model to make decisions for you, please talk to your counsel, talk to your in-house or outside counsel about that and ways to manage that risk and what the risks of those are. And so we'll talk more about that towards the end of our very brief half-hour presentation here. So this is just a quick hint, this is just a taste, but there's all of this range of applications out there, more than just recruiting and selection and hiring. And I think what DEI practitioners, what HR practitioners are reaching for here is, yes, there are ways that these AI tools are enhancing, or they're seeking to use AI to enhance those processes. And there's other ways that AI, including large language models, are helping folks get to their DEI goals and to avoid bias. And so with that, I'll turn it over to Seyfarth partner Angelina Evans, who's going to talk a little bit about risks and regulation of AI. Angelina?
Thank you. Thank you so much, Rachel. So good morning or good afternoon, depending again on where you're joining from. I am joining you from the downtown Los Angeles office of Seyfarth Shaw. I'm a partner in the Labor and Employment Group. So, my portion of this presentation to you, we've gotten a taste and a touch on all of the great ways that AI can be used to meet DEIB goals. And we've seen the numbers. We know companies are using them. We know that they have an absolutely, significant impact on reaching these goals. But it would not be a legal webinar if we didn't discuss some of the risks in using them. So what I want to do is really talk to you kind of in two perspectives. One is the regulatory risk that's created from the use of these tools, and that really stems from a failure to comply with legislation that's coming out of various states. Then the second type of risk that I want to talk to you about are litigation risks. That's what I think of as litigation risk. Does this tool that you're using create an adverse impact on a protected group of people in terms of employment decision making? Is the tool being used, as Charlotte Burrow says, as a high-tech way to discriminate against people that are within a particular protected category? So one of the things that, it's important to note is, and it's right here on this slide, is that, most of these AI tools are being used with the goal of neutrality and objectivity and frankly, cost savings, right? Because they're certainly less expensive to use these tools than it is to hire a group of humans to, do recruiting and retention and things like that. So the issue is that, despite the positive and the positive thought behind using these tools, they do have the ability to either reproduce or introduce bias depending on the data that they're trained with, and depending on what groups of individuals have been used to provide the data that they're using. So let's go ahead and switch to the next slide. So starting with regulatory risk, and as it says at the top of the slide, there really is no federal legislation right now on the use of AI tools. There is guidance that's been put out, and there's different things that are suggested. But the only thing we have in the United States thus far are a few states that either have laws on the books already, or some that are very close to being on the books. So one of the first ones is New York City's local law 144, and that's been in effect since July of last year. And essentially what it provides is that an employer is using, and it's called an AEDT, an automated employment decision-making tool, in relation to a job in New York City. There's a couple of requirements that you got to meet. First, you got to provide notice to the applicants that an AEDT is going to be used to screen or make a decision related to your employment. And two, you've got to conduct a bias audit before the tool is even used. And then three, you've got to publish the results of that bias audit, which includes essentially a summary of the data that was used, the number of applicants, number of candidates, their selection and scoring rates. There's a lot of detail that need to be provided in the bias audit, and that needs to be made publicly available. Now, the failure to comply with those requirements comes with penalties. If you do not comply, the penalties range from either $500 to $1,500 per affected candidate. So they can be significant. The second law that's on the books is Colorado's law, and this is actually the country's first comprehensive law that establishes compliance requirements for development of what are considered high-risk AI systems. And I'm going to focus on high risk because we're short on time, and also because anything that's employment related is going to be considered high risk. So essentially, the law requires, very similar to New York, notice that the tool is being used, but Colorado goes further. You've got to also disclose the purpose and nature of the decision that's being made. You've got to provide contact information for the deployer of the tool, so they separate the law in between the folks that are deploying it, using it, usually the employer, and also developers, the folks that have created the tool in the first place. And then you've got to provide a plain language description of the AI system, and you also need to provide the employee or candidate an opportunity to opt out of the use of that tool. You've got to employers also have to post a public statement on their website that summarizes the type of systems that are currently being deployed and how they're managing the risks of algorithmic discrimination. One additional kind of burdensome issue that this law provides is that employers have to give employees the opportunity to correct erroneous personal data that may have been used in making that quote unquote consequential decision relating to their employment. And they have to give the employee or the candidate an opportunity to appeal the decision when it's quote technically feasible. And that appeal process needs to include some sort of human review. Impact assessments are also required under the Colorado law, similar to the bias audits under New York. And if you are a developer of the tool rather than deployer, you've got to provide certain notices to the deployer. California got very close to getting a law passed that's very similar to Colorado, but it actually just died this past Saturday. So I'm sure that it will be revived during next year's legislative session. We've kind of all been waiting with our holding our breaths for that law to pass in California, but it has not yet made it out of the gate. Illinois' law is another one that's on the books. And it requires employers, again, to provide notice to applicants and employees that the employer is using an AI system. And it's an amendment to, oh, my light switch just went out, but hopefully you can all still see me. It's an amendment to the human rights law. So it basically expressly prohibits discrimination using artificial intelligence. So look, in general, what we're seeing from the states and what I suspect we'll see from states that follow along is that you're going to require a few things in order to be in compliance with these laws. One is that you've got to provide transparency and notice that a tool is actually being used. There's got to be some manner of bias auditing or impact assessment, however you want to coin it, and reporting to whatever governmental agency is doing the enforcement for these laws. And there's got to be some risk management system developed within your organization that includes some manner of human oversight. So testing, retesting of the tool, things like that, to make sure that you remain in compliance. Now, I raise these issues about regulatory risk because, like I said, non-compliance comes with penalties. So employers really need to be taking a real hard look at the various aspects of their company and whether these tools are being used, whether it's HR or otherwise, because there's going to be certain steps that you'll need to take to remain in compliance with these laws. So moving on to the litigation risk, and we can go ahead and move past this slide. So this is really just to let you know that, look, federal government, various agencies are absolutely paying attention to the use of AI in employment and otherwise. This slide just contains a list of the different agencies that have put out guidance regarding AIs. The EEOC on the next slide has also put out guidance. Their guidance was specific to potential discriminatory impacts against individuals that have disabilities. So lots of good guidance that's out there. But essentially the bottom line is that, look, we cannot be using AI in a way that has a disparate impact on certain groups of people. That is going to remain illegal as it is under any discrimination law. So, this slide that we're talking about, the governing law and the legal framework. So look, as a starting point is kind of what I was getting to in my last statement, is that the civil rights laws prohibiting discrimination are going to apply to artificial intelligence. In some ways, it seems like new laws might need to be created, but at the core, if you're using a system that creates an adverse impact on a group of people who share a protected characteristic, then you're going to be in trouble and potentially in violation of some either state or federal anti-discrimination laws. We talked about at the top of the hour, or top of the hour, how AI can be used to meet DEIB goals. And so, it's at this point that I just want to remind folks that, race and gender-based preferences are unlawful, right? There's a very narrow exception to that, and that is when the goal and the preference is designed and it's narrowly tailored to correct a manifest imbalance in the workplace, right? So then it might be okay. And the idea behind this is that we can use these tools to correct a manifest imbalance, but we've got, it's a balancing act, right? Because if we do too much, we risk reverse discrimination lawsuits, which we're seeing on the rise now. And if we do too little, then we risk traditional discrimination lawsuits. It's important to understand how the regulations and the litigation risks are tied together, because just like we saw in the Pay Transparency Act, when that was passed in various states, it highlighted the inequities and salary disparities for the public, and so too will these bias audits and things like that, and disclosure requirements that are going to put the public on notice as to what data is being used, what are the selection rates, things like that. So we might end up seeing additional litigation stemming from that. You can go ahead to the next slide. Yeah, and this is really just a visual representation of the risk areas that employers will face when implementing a DEIB program. And again, these are real risks, especially considering that there's going to be some transparency required as these new rules and regulations get rolled out across the states. So final slide for me. Yeah. So, how do we avoid the risk as much as possible? And I know Rachel's going to give us some best practices in the next minute or two, but, get counsel involved. We're going to have to do these audits. You're going to have to do DEIB audits and AI impact assessments, bias audits. Those audits should really be something that's done under the cover of privilege. You want to make sure that you're figuring out what the holes are or what the problems are in the product that you're using or the system that you're using, and address it before the tool is put into effect, and certainly before it's shared with any sort of governmental agency that's enforcing the regulations that we talked about. And I'll turn it over to Rachel. You are muted, Rachel.
That's embarrassing. Thank you. And before we move on, from this section, I'd like to return to one of my original points about AI applications, which is that they are not all created equal, and risks are not all created equal. That some of the regulations that we're seeing, some of the AI-driven decisions that regulators and folks looking to sue employers and to enforce existing laws are concerned about have to deal with high risk applications or consequential decisions, depending on how what terms they're using. And there's different applications that can be used to support your HR processes, used to support your goals. We're talking a lot about hiring and a lot about the risks on hiring and disparate impact in that context. But again, thinking about lawful DEI goals, one of the things that I think folks would agree is part of a lawful DEI program is advertising jobs, making job postings better known or better advertised to diverse populations. And there are ways that your diversity sourcing practices can be supported by AI. And just because you're using technology, you can't use technology to do something that the human being couldn't do using the human decision making. So it's not a get out of jail free card there, but there are efficiencies on that process. Plus, there are ways that the use of the AI tool, the hope is that it is more fair, that it eliminates unlawful bias. So on the regulatory front, we have existing laws applying to the results of AI, and we have regulators talking about now a much greater concern about the process. And so some of the laws that we've seen in Colorado and the proposed laws that almost made it across the finish line in Connecticut and California are looking at the process, on looking at risk management. The federal government is also weighing in on this. OFCCP, the Department of Labor, talking to federal contractors, but really I think a warning call to people outside of the federal contractor sphere is talking about the use of AI for selection procedures. What OFCCP's principles, their principles to avoid discrimination, they're strongly rooted. The promising practices are strongly rooted in a document from NIST, the National Institutes of Standard and Technology, on AI risk management. NIST calls it the risk management framework. And what I've been saying this entire presentation, NIST is encouraging people to understand that not all AI risk is equivalent, that there are unique technology risks, and there are unique and there are ways that those technology risks interact with the people processes. So again, if you're asking ChatGPT to make some employment decisions for you, that has a bunch of technology risks, please don't do that without talking to your client, without talking to your lawyers, right? But also the human side of there's this technology tool that could be neutral, that might be very useful, but the human being asking ChatGPT to make those decisions for you, that's creating that societal application risk. And it's the intersection of these two different kind of risks. What's the technology and how are you using it? That I think these promising practices, that these risk management practices really hone in on. So my parting thoughts for you, my parting thoughts for you starts with a truism from data science, a truism from mathematics, which says, kind of provocatively, all models are wrong, some models are useful. So remember, with AI, we're talking about mathematical models here. And we're talking about mathematical models about people, about tools that we're using for decisions or to help make decisions about people. And so acknowledging that these mathematical models, these AI models can be wrong, will be wrong. There are circumstances that they will be wrong. The questions are, okay, well, does that mean that we're not going to use them at all? In some instances, the advice has been yes. And in other instances, it's a yes, but. And it depends. I hate that, it's like, lawyer on a webinar saying it depends, right? But it depends on what is the application and what is not just the risk that it's wrong, but what are you going to do when it is wrong? So when you're thinking about using any of these AI products out there, including just generic large language models about that you can use as part of your decision making or as part of your DEI efforts, part of the fundamental question, the first question is, what are you trying to accomplish? What result are you reaching for? How does using this technology help you reach your goal? And part of that is some of these AI applications are going to be lower risk than others. A lot of the lawyer conversations here about risk are for consequential decisions. Are we using AI? Are we using technology to make decisions about people and their employment or employment opportunities? And if that is automated decision making, that comes with elevated risk. But if we're talking about, hey, help me write a better performance evaluation, help me to understand what skills I might need myself to develop based on some existing, to help me do my job better. Those are lower risk applications. They're not without risk. The model still could be wrong. But if the model is wrong on those lower risk applications, the consequences are much different for you. Okay, so human in the loop. How is human decision making being assisted or replaced? I think that is a key component here. Admittedly, part of the benefit of automation is that you're not having humans do everything, but where is your intended application supplementing human judgment? Again, if we're having a large language model like ChatGPT help a manager write a better or more fair performance evaluation, that's different than saying, I just want the AI to write the performance evaluation itself, okay? And then again, thinking about wrongness and bias, understanding that there are ways that these mathematical models, including large language models, including these vendor products, can be wrong, can have bias. And so there's testing and monitoring that comes along with that. And as OFCCP and other people involved in risk management tell us, there's particular risks when you have an employer looking solely at the vendor, at their AI vendor for some of the testing and monitoring. So lots to think about here, but don't lose sight of those fundamental questions. What are you trying to accomplish? And what if the AI is wrong? How is it going to be wrong? With that, we are out of time on this very brief webinar. Our CLE code is S as in Seyfarth Shaw 4580. Again, our CLE code is S4580. I will leave this slide up on the screen for a little bit more. And with that, I will thank you very much for attending. And if you have any questions, please feel free to reach out to us or your Seyfarth attorney. Thank you.